Law Simplified with Justice is anchored by Justice Maduforo. Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen, and welcome to Law Simplified with Justice. I remain your usual regular host, Justice Maduforo. I'm a solicitor of the Senior Court of England and Wales, and I'm also barrister and solicitor of the Supreme Court of Nigeria. Ladies and gentlemen, you know I'm also a police station and magistrate court duty solicitor of England and Wales. This program has always brought the best to you, and I'm very proud to always bring this program to you. Why? Because somebody's life, somebody's future is being changed by taking action, by contacting us from this telecast. Therefore, whatever I say on this program, all my discussions, those of you that follow this program, either on this program, on this platform, Believe TV, Sky Channel 592, or on YouTube, you know that whatever I say on my discussion, they are not legal advice. Therefore, you should not act on them. But rather, the information and the details, contact details on the screen, for you to come to the office, book an appointment to see me one-on-one. And in that circumstance, and at that stage, having taken proper instruction from you, you can then act and run with whatever advice I've given you. Ladies and gentlemen, I have presented before you on the show criminal matters, I've discussed it, contract matters, employment, immigration, and family, oil and gas in respect to contracting and commercial contracting. Ladies and gentlemen, I've also discussed these areas. And today, I'm going to be discussing immigration law. And the topic today, and I'm going to blow your mind, the topic today I'm going to be discussing is certification. Immigration certification. Certification. Some of you may not come across that because it's always under the lowest print in the refusal letter you receive from the Home Office. It's always written at the last chapter of the letters of refusal. If you or any one of you have received letters from the Home Office recently, you will find out that at the bottom conclusion of the refusal letter is either your matter is given right of appeal or it is certified. Ladies and gentlemen, that is what I'm talking about today. But you know that I do not discuss it in terms of in detail, of which for you to understand and begin to act on. No, it's for you to raise, it's for you to take action. First of all, raise a consciousness to come to realize what that means, what leads to such certification from the Home Office, and then what you need to do. That is why this program kickstarts your consciousness. If it's not for you, you can pass it over to somebody else that needs this information. The same way, not only in immigration, in employment, in contract, in criminal matter, from the police station to the magistrate court. As I told you before, I am police station and magistrate court accredited duty solicitor, which means that in matters of crime, matters of extradition, matters of confiscation, matters of whatever sort of it, as little as matters of common assault, all the way to murder. You know that you have me to represent you, appeal for you against conviction, sentence, and all that. So I need not say much into that, because I'm not discussing crime today. I'm focusing on immigration certification. Now, let me go further. Certification. What is certification? Now, when you make an application to the Home Office, the basis of your application is for you to be granted. And some of you may not be granted, but the Home Office will give you right of appeal. Some of you have right of appeal, which you got to exercise within 14 days. Some of you don't have right of appeal, which means that you can now look for another way of judicial review or rest of them, depending on whether you have any case or not to deal with that. Now, I'm marshalling out this point for you to understand that what you are going through, I know it and I understand it. But just the fact that you got to take further steps to galvanize your case and to actualize a successful outcome. And how do you do so? Now, as I said, certification is a power given to the Home Office by Parliament under the Nationality and Immigration Asylum Act 2002, Section 94, given to the Secretary of State to certify that your human rights claim, to satisfy that asylum claim. Ladies and gentlemen, now that is for those of you who will claim asylum or relying under the Human Rights Act, be it Article 2, Article 3, Article 8, whatever article you're relying on in your claim, which is under the Human Rights Act or the European Convention on Human Rights. Ladies and gentlemen, whatever application you've made, the Home Office have considered it. Some of you will be sure that at the last print, you will see the Home Office said, having considered your application, and it's clear, and we are satisfied, the Secretary of State is satisfied that your human rights claim is completely and clearly unfounded. Those words are the key factor. And what makes the Secretary of State conclude that your case is clearly unfounded? This is what matter I will more take and discuss with you when you come to the office. Ladies and gentlemen, now certification is provided by that section 94 of the Nationality Immigration Asylum Act 2002. Now, that's for those applications. Now, for those of you who are also about to be deported, those of you who are facing deportation, either by notice of deportation served or a decision for deportation made. And ladies and gentlemen, and the Home Office have considered your representation on your further appeal and concluded that it's clearly unfounded. Now, the law moved further away from 2002, where that power under Section 94 was given to the Secretary of State. Now, along the line, the new law came in 2014, which is the Immigration Act 2014, fused in what is called Section 94B into the Immigration Act of 2014. What does that mean? Giving the Secretary of State additional power to certify that human rights claim against your deportation as clearly unfounded. Now, this is a two section. They are not the same. Section 94 decision and Section 94B decision under certification are not the same. They are on two different applications that you make. Now, you may not know that. Now, some of your words are facing deportation. Some of you have clearly received a decision that is clearly unfounded and therefore certify your case. What does certification that means? From what I've explained, it simply means that you don't have any claim. Your claim for human rights is baseless. It's absolutely cannot stand it. It cannot stand the scrutiny of legal or legal proceedings. So therefore, it has really no point to hear your matter further. Therefore, to shut it down and giving you right of appeal, but to exercise it out country, which means go back to your country and lodge your right of appeal. And therefore, it's called deport first, appeal later. Deport first, appeal later. That is under Section 94B. Now, Section 94 has its own connotation of its own, as I explained to you. So, this is certification. Certification. Whether or not that decision or that rule breaches your human right or breaches Article 6, which is the right to fair hearing, is another matter which the court has also interpreted based on, obviously, by case basis, which means that your case may be different from that of B in respect to whether or not to clearly found your case unfounded, or in such a situation, not certified, but give you a right of appeal here. Now, taking this thing further, all the certification, there's a lot of argument going further back and front. And there's a court of appeal decision recently in relation to that certification. And what the court of appeal say will shock your mind. But what the court of appeal say is in relation to another sector of that certification, which I explained. Now, my purpose is not to reel out this theoretical legal interpretation of the parliament or legislation, but however, is the purpose or the action which you need to take first before you get to certification. Certification cannot just come up, or the Secretary of State, through his case workers, cannot just come up and certify your case. If your case is weak, that's what I'm saying, therefore, you will be at risk of certification. And once you certify your case, and your case is satisfied, which means that you can no longer appeal in this country. You got to appeal when you have left the United Kingdom. Now, there are other ways to come across certified applications to deal with it much better. And how do you do that? When you come to see me in the office. When you come to see me in the office, I will take detailed instruction from you. If you have already been, your case already been certified, and you already decided to go, think twice, or you decided to do something else, think twice. Come and see me first. And I want to take detailed instruction from you. I'll be able to understand whether that certification needs to be challenged or not. Now, how do you challenge certification? Certifications made by the Secretary of State cannot be challenged by way of appeal. It's challenged only by way of judicial review. But you got to be careful when you challenge it by judicial review, whether or not you have any case at all to challenge in judicial review, or you don't have any at all. The fact that it's satisfied, are you accepting it on the full basis that, yes, I know I don't have no case? No, the Secretary of State is always apt to refuse. So therefore, do not be dismayed when you receive letters that your case has been satisfied as clearly unfounded. That's not correct until I say so, until justice says so, until I've looked at this case, take instruction from you, look at the circumstances, look at your personal circumstances, look at the current circumstances different from the one you applied before, and I will be able to marry the two together, merge them together, and I'll be able to tell you whether or not the Secretary of State is wrong or right, and whether or not you need to take a step further, in this instance, by way of judicial review. Certification. Certification is very crucial. It has a direct consequences, which is why I said before that you cannot appeal in this country. It must be out country. Now, recently, the Secretary of State is enjoying that power to certify your case. Some people have come to me of the cases, having watched this program, and they found out that their case has been satisfied. They come back to me. And when they come to me to go through their case, I always understand the reason why it was certified. Now, the reason I brought this topic is that you need to avoid getting your case certified. Some of you that like to do these applications yourself, as I said, and I always say in this program, the Immigration Act and immigration applications, appeals, and every proceedings that have to do with immigration has completely changed. It's not as it used to be, and therefore it requires that legal mind, that eagle eye, to understand interpret the legislation, the parliamentary and the ministerial decisions and ministerial statements, to also interpret court cases and case laws that deals with such applications, and to use whatever is beneficial in there to change the cost of your application. Some of you can just not barely make any step further simply because your case has been certified. Do not lose sleep over it until you come to me to take proper detailed instruction from you. Then you can know that clearly you need to either accept what I said to you at that stage or leave it. Ladies and gentlemen, I'm discussing immigration, and the topic is certification. Certification in your application made to the Home Office under the relevant sections of the law. But how do you deal with certification? Ladies and gentlemen, it's always a pleasure to employ your mind and bring something that you do not think is vital. And why do I say so? It's because some of you are naive, not understanding the law, or probably gone to those who really didn't understand the law properly, and I don't blame them at that point in time, but they didn't understand the working of the law at the time. And so when they made this application for you, it did not work well. But guess what? You now have the opportunity to now rectify that by coming to the firm and to the solicitor that can deal with these matters effectively in the right manner and change the cost of that application. I will take a very short break now. I'll return back. Don't change the dial, and I will take you further to certification.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.
Hello, welcome back to Law Simplified with Justice. Before I took a short break, I did introduce to you certification in immigration applications. And the reason being that currently it is now a very vital tool to the hands of the Home Office, the Secretary of State, or the Home Department, to refuse your application and certify it. In that case, they have cut you short from appealing. They've cut short your expectation to appeal. They cut short your expectation to continue to live here in the UK while your appeal is pending, to those of you who have lived to remain when you made the application. Because if you made application where your leave to remain is was still valid, and they still found out that the application you made to extend has clearly no solid basis for which to proceed to be heard in the first year tribunal, then they will refuse the application and certify it. Now, what does that mean? That means that the person whose case has been certified has cut short this right to continue to stay in the United Kingdom and work, because the right of appeal has now been cut short and reversing you back to appeal it, but from your country of origin. Ladies and gentlemen, that has their consequences for those who already have leave to remain ongoing. For those who don't have leave to remain ongoing, but have made an application, and under Article 8, mostly application Article 8, private and family life, fused together or single, and the Home Office have considered the circumstances of the person and have satisfied that application, that it becomes a problematic situation for that individual, because it then means that no more going further to appeal, because the chances of success in immigration applications sometimes stands very well when you come before an impartial immigration judge. Trust me, a lot of them, a lot of decisions we won are mostly before the first year tribunal and upper tribunal, because they're impartial people. Lately, as I said to you, the Home Office are using this tool, which is refuse your application, certify. Or if you're facing deportation and you claiming Article 8 or other human rights claims, and they will take the decision to certify that your human rights claim, and then actually giving you the right of appeal. They will say to you, of course, you're looking for right of appeal. Yes, we're happy to give you. Take it. But don't exercise it here. Do it from your country. So it's a confusing state for the individual. Means that I don't have right of appeal, but you have given it to me to appeal it from outside, which means that you have to go do it from your country of origin and then appeal further in here. It has its own consequences. It has its own issues in respect to dealing with such matters in court here, while the subject matter, the individual, is outside the shores of this country, outside the jurisdiction of the court, which he is expecting fairness from. This is the problem. But whether or not natural justice has been fulfilled in this circumstance where you are deport an appeal letter or you are removed to appeal letter, the question is that whether the natural justice has been violated, whether the right to fair hearing has been violated. I can shock your mind, because this matter has come before the Court of Appeal recently in October 2015. The Court of Appeal took a very drastic decision, obviously in a way that tilted towards the Secretary of State, especially under Section 94B of the Nationality, Immigration and Asylum Act 2002, brought into force by the Immigration Act of 2014. Because it's a new piece of legislation that came in, it now tied the hands of applicants and I gave and boosted the Home Office enormous momentum to carry on to refuse your application and then ask you to give you right of appeal to appeal it from your country of origin. Now, that concept, that decision, that judgment by the Court of Appeal, but which is not within the parameters of Section 94(1) of the same Act, but the principles behind that decision is what the Home Office have now employed into applications that are non-criminal matters. Remember that deportations have to deal with whether you will be committed to a criminal offense one way or the other, or even in some certain circumstances, extradition, if you are facing extradition. So in that circumstance where the right of appeal against the extradition decision is a different thing entirely, whether the Home Office will also certify your human rights claim under extradition laws. That's a different matter entirely, ladies and gentlemen. But I'm concentrating on the deportation now and removal. Section 94(1) deals with removal. Section 94B deals with deportation. But in all said and done, it all deals with the human rights claim infused into such applications, into such decisions, of which you are applying to the Secretary of State and asking the court to remove and quash, or rather dismiss or uphold your appeal against that decision. But the Secretary of State now, which has the power given to it by Parliament, passed as a law, has now the power to certify your case. In certain circumstances, in certain quarters, we have come to argue and obviously deliberated on the fact that Home Office has been given the power of that of the judge and the decision maker, which means that they decide your matter and they say it has no merit. When it has not come before a judge, when it has not come before a judge, which is why they're using the power to say, we are not depriving you of your right of appeal to challenge our decision. The only thing is that you have to challenge it from your country of origin after you've left. If you haven't left here, you cannot appeal. And the problem is that if you haven't appealed within the time given to you when you are outside of this country, you may lose the right of appeal. So that brought the purpose now. What do you do in that circumstance when you're given the right of appeal to appeal but outside of the country? Now, this is why I explain this. The Court of Appeal decision is also very crucial because this is a very recent decision which is empowering the Secretary of State, which is why some of you, if you can go back to your decision letter, refusal letters, or your friends or whoever is sitting on an immigration application today and have received decisions, especially when you make an application based on your private life, you've come to realize that there's a certification in there. Now, why do you want to get to the point where your matter is satisfied? Why? That is the point. That is the focal point of this telecast, of this program. My purpose and my goal is that rather than wait till you get the certification and now start dealing with issues which it may be difficult for you to surmount, difficult for you to override the decision of the Secretary of State, why would you not now make a fortified application first? Now, that's why I told you, when I make applications for you, advocate for you in courts, in the tribunal, immigration tribunal, employment tribunal, county courts, magistrate court, when I advocate for you, when I litigate for you in matters from the employment tribunal all the way up to the employment appeal tribunal, to the upper tribunal, to the high court, from county court to the high court of justice, and also to the magistrate court, to the crown court and court of appeal, when I litigate in those circumstances, I am futuristic, which means that whatever I pretend to be a stumbling block in future, I have already fortified it in that litigation, in that application, in the first instance. So that is very key. How do you know what to fortify in there? You may not know that. The next person you go to may not know that until you come to the person who understands what it takes, who understands what is required at the point in time to make such application and make it beautiful. And make it beautiful. You see, I do not care when they refuse application because it is only a stone for achieving a successful appeal. Because you know why? As I tell you, I do not want it to be refused in the first instance. I'm always receiving the decision granted in the first instance. But even if it's refused, because I have dealt with what is required in that application, then I will smile all the way to the Court of Appeal. I'll smile all the way to the Employment Tribunal. I'll smile all the way to the First Immigration Tribunal. I'll smile all the way because I have dealt with it. I'll smile all the way to the Magistrate Court if I represent you at the police station and for a criminal allegation against you. And I've advised you what to do. And you run with my advice. I will run with that, stay on that, and set you free in the Magistrate Court during the trial. Ladies and gentlemen, that's why I said the foundation of a matter is the synchronym to the strength of such item, of such product, or such building, or such case. It is very key. Foundation can never be separated from the application or from the main subject matter because foundation is key to successful application in immigration, successful application in employment, successful application in county court. When you draft your case in contract solidly well, fortify the clauses that's required in that contract, that is a very good strength and a standing point for you to succeed in challenging that contract, in dismantling that contract, whether it's a breach of it or performance of such a contract. Ladies and gentlemen, that is very important. That is why I concentrate. I put a whole lot of strength in making sure the foundation stands strong. The strength of the building is not in the beauty that you behold on it. Foundation is within. The beauty of the house which you behold, a finished product of the building, is only a finished product. But the beauty of that building that's keeping it standing is the foundation. When the foundation gives way, the building collapses. Ladies and gentlemen, it is very important that you understand that foundation is very key, which is why before you get your case certified, you have to make sure that you have fortified it first, dealt with it in a solid foundation, of which that it can stand properly well, and that you can be able to sustain an application. Ladies and gentlemen, I am discussing certification. Certification in immigration application. Certification by the Secretary of State. If you are sitting on certification, if your case has been certified as clearly unfounded by the Secretary of State with no prospect of success, with no prospect of chances of success in appeal, and the second of state is on its own, believe that you have no chances. Therefore, run to the firm that can challenge that decision and can change it around. But for your applications to stand and succeed in the first instance without any thinking or expectation of certification, that's when you come to Tice Madox Solicitors, when I prepare your application, when we galvanize your application, when we appeal for you, you have all the way to succeed. I don't have all the time, as I keep telling you on this program. I have no much time. My time is to present this, kickstart your consciousness, make you sure that information is key. But that information will be messed up if you just take it and run it by yourself. That information is only useful when you take the telephone number, call us on the screen, adverts on the television, displayed on the screen. The landline is on the screen. You can contact us via email. It's on the screen. You can check us out also on our website, ticemadox.com. You can check us on YouTube. Add us as friend on Tice Madox Solicitors on our Facebook. And ladies and gentlemen, you can also follow us on our Twitter at Tice_Madox. I am so grateful to present this topic to you. I wish I could run on and on, but I can't. But next time I come your way again, I ask you to stay focused, stay positive. Your time has come.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.